So late Tuesday, the Attorney General filed a motion to compel 3 individuals to comply with subpoenas that were issued and to come forward and give testimony, which they're required to do under these subpoenas that were properly served. And she did that by filing a 115-page document that supported the arguments that she believes favor her position, and that would require the court to command that these people come and speak to her. Well, they're looking at the Trump organization and several different variations of that organization, and then the 3 principal players in the organization: Donald Trump, his daughter, and his son. And those are the 3 people to whom subpoenas have been issued, and those are the people who are the focus of this response to the motion to quash. And so the wrongdoing that's being looked at here by the Attorney General is the overvaluation of these properties in certain documents that were provided to support certain loans and other instances where value of property became important for the Attorney General. Based on the response that was filed by the Attorney General, there appears to be a good faith basis for issuing the subpoena, and then based on the facts that they've placed and the allegations they've made in their response, it seems to me that based on my experience, the judge is going to deny the motion to quash and is going to require these individuals to appear before the Attorney General and to answer the questions under oath as required by these subpoenas. The shortest route is for them to come forward and either answer the questions or invoke their rights under the 5th Amendment, and then the AG will be able to complete her investigation in a matter of weeks or months, and perhaps it's springtime they'll be done. If they're going to seek to continue to fight these subpoenas and either deal with a contempt hearing or take it up to another level at a court of appeals, this thing's going to drag out for 6 months, 8 months, potentially longer. If the legal counsel you have believes that these subpoenas were improperly issued because they were too broad, they weren't based on facts that would support issuing these subpoenas, then I certainly would think that that's the route your lawyers are going to take. You're going to fight back against subpoenas that you believe were improperly issued. And so that's what they've done here, and that's what they're trying to do, so they don't even have to cross the threshold to the point where they might be required to comply and either assert a 5th Amendment right or decide that they're not going to comply with the subpoena and face contempt. So the first step is always going to be, were these properly issued? Are they legal under the statute for which they were issued and under the facts upon which they were based? And if the answer to that is we believe not, then that's the route to take, and that's the route that they've taken here. And so it's not surprising to see a motion to quash that's going to have to be resolved before you even get to the issue of, am I going to come forward and answer the questions, or am I going to assert my 5th Amendment rights?